under advisement. I will now call case number 128008 in the matter of Carolyn Sue Edwards.
Madam Chief Justice, may it please the court. Alice Walker, Deputy Disciplinary Administrator, on behalf of the Office of the Disciplinary Administrator, I have reserved 3 minutes for rebuttal. This is an original proceeding in attorney discipline involving the respondent, Carolyn Sue Edwards, who has been licensed to practice law in the state of Kansas since 1986. This matter comes before this court following a formal hearing involving 2 separate disciplinary complaints. That hearing was held in June of this year, and prior to that hearing, the parties entered into a stipulation regarding the facts in both of those cases, as well as the rules violated in both cases. Therefore, the hearing went forward only on aggravating and mitigating evidence. At the conclusion of the hearing, the disciplinary administrator's office recommended that the respondent's license to practice law be suspended for a period of 6 months, and that should be required to undergo a reinstatement hearing. The respondent requested that her license to practice law be suspended for a period of 3 years, but that be stayed for a 3-year probationary period. The final hearing report was issued on August 2nd of this year, and in that report, the hearing panel adopted the respondent's recommendation of a 3-year suspension, but that it be stayed for that 3-year probationary period. They did make recommendations of additional conditions that should be implemented in the respondent's probation plan, including that instead of tapering off the weekly meetings with the practice supervisor, that she continue to meet weekly for the 3-year period, that there be an additional requirement that the practice supervisor periodically audit her communication with her clients. And then it also recommended a specific amount of money that should be refunded to the client in what I'll call the estate case, one of the complaints. Neither party filed exceptions in this case, therefore under 228G, the findings of facts and conclusions of law are deemed admitted. However, the disciplinary administrator reserved its right to contest the discipline recommended by the hearing panel. And I do want the court to know that today I'm maintaining my recommendation that the appropriate discipline in this case is a 6-month suspension with the requirement of reinstatement hearing.
I have just kind of an evidentiary question to begin with. In the restitution, I guess they said restitution in the estate case, $40,986.25. Now, I've reviewed the timesheets, and that actually her numbers differ. I mean, how did the hearing panel come to that number? Do you know?
I am unsure how the hearing panel came to that number. The disciplinary administrator's office has not made any recommendation of restitution because of the matter of the probate cases where the attorney fees must be approved by the probate court. That has never been requested, as far as I know in this case, at least at the time of the hearing. There had been no request to approve, and it was $84,000 total that client paid, and there has been no request for any of that. I think it's the $46,000 is on her timesheet. That was not a contemporaneous timesheet. That's something she did through the disciplinary case, trying to go back and estimate what she was, I think on her hourly basis, what she put into that case. I'm unsure how the hearing panel, I don't have the final hearing report directly in front of me. I know that they maybe looked at that and the type of case that was done and the amount spent, but I'm not sure how they came up with that specific number.
Okay, and in that probate case, and as I went through and you know, we have a copy of the retroactive billing summary or billing timesheets, retroactive timesheets. And, you know, for the amount of time, which I don't know, it was $43,957, so whatever that is. What outcome did the victims in this case, I mean, what, you know, there was all this review, meet with clients, but what actually was done?
The record will show that at the time that the respondent they hired new counsel, I think that was in maybe August of 2021, that they had Tim O'Sullivan come on, that there was no conclusion to the probate case. There had also, one of the things that they had requested was for a motion in order to correct the death certificate, as it had the wrong social security number, and that had not been done at that time either. And so as far as an outcome for those clients, I don't know that there was any at the time that they had to get new counsel.
Well, let me put it this way, beyond reviewing things, what did she do for these clients for what was 84,000? But I guess, okay, so she, her retroactive billing timesheet shows $43,957. Beyond reviewing things, what did the clients get? What?
That's why I believe the hearing panel found that there was actual injury to the client, because that case kind of languished for quite some time. And in the exhibits in the or the disciplinary administrator's office exhibits, there's the email communication back and forth. Have you done this? Do we have an update on this? And there's really no progress in any of that
Right.
throughout that entire period.
I guess my bottom line is why should the clients, the victims here, have to eat $43,957?
And
Why did the hearing panel determine that?
And unfortunately, I cannot answer that question. I don't have a recommendation as far as the amount to be refunded to those clients. I think that that's a probate court question. I certainly think if this court were to review, this court could have the authority to make a ruling on that, but it had never been submitted to the probate court, who could review and say, here's the work that had actually been done, coupled to what she said she did, and whether that's appropriate under the probate code.
But where the fees weren't paid by the estate, they were paid by the victim, correct?
But out of the estate, I think they have one of the exhibits, the complainant, who was the client and the victim in the matter, kind of went through what they had paid through that process.
Through what process?
Through, and I don't have it in front of me, what exhibit number it is, but it talks about how the exhibit makes it look that she's paying it out of the estate, out of some funding that she has.
He wrote checks without approval from the court
Correct.
in order
the
to
court.
pay these
Okay.
fees.
Correct.
I'm still trying to figure it. So how does the probate court get a jurisdiction over this money that was not paid? In terms of your recommendation, your lack of a recommendation on what to do about the money, I'm still trying to figure out how even the probate court's going to be able to fix that. Shouldn't there be something in your recommendation about how this person gets their money back if it wasn't appropriately approved by the probate court? I don't get this.
And if we were going to go that far, I think what my recommendation would be, if none of it was approved, and therefore none of those fees should have been paid by that client.
But why wouldn't your recommendation be that she have to, before she gets reinstated, she's got to pay back the money?
And that was not something I recommended at the hearing panel. We didn't fully go into that amount of restitution. With the court's permission, a little bit of something that's outside the record were conversations with Mr. O'Sullivan, and that case was still ongoing. So there were ways in which the respondent, I think, could have filed a motion with the court asking for consideration of those fees at the time that the hearing was going on in our case. But I don't know that the disciplinary administrator's office is in a position to try and analyze what the probate court would have approved in that case.
And it is in the record, because there was some question, well, I guess you're saying there's something in the record that shows that this money was taken out of the estate. It wasn't paid for by the victims.
I'd have to look back at that exact exhibit that was submitted by the complainant. And I don't know that it says where she's paying that money from, where
If there's nothing to show where it's paid from, then
I think her exhibit suggests that it's coming from something that she had access to through the estate, or she is. And that could be an assumption that I've made looking at that exhibit. I can't recall which one it is. It's part of the complaint that was issued in that case.
Okay, thank you.
I'll jump in with a sort of big picture question. This case presents an anomaly, or that's how I look at it, that has come up again and again and again, which is respondent requesting a 3-year suspension and disciplinary administrator's office requesting or recommending a 6-month suspension. And obviously the difference is whether there's probation or not. So that leads to my question, which is it appropriate for this court in disciplinary cases to essentially consider the entire discipline as a package, or should we be determining the period of suspension independently of the secondary consideration of whether there should be a probation? Because if we do it the first way, it strikes me that it gets our suspension periods completely out of whack. At least that's my fear. Does that make sense?
It does make sense.
So I just would ask for your response to that.
And I can say, at least in this case, when I was looking at what is the appropriate discipline, I tried to look at past cases that may be similarly situated. And what, as we're looking at the facts that led to the rule violations, coupled with the ABA standards, what is the appropriate discipline? And in this case specifically, I actually looked back at In re Cupca, which was in 2020. That actually was a 2-year suspension. And after 9 months, she could seek early reinstatement. I looked at some other cases, but believed that based on this misconduct, in light of the significant mitigating factors, a 6-month suspension was appropriate. And then on top of that, I'm asking for the reinstatement hearing to ensure that there are the adequate safeguards in place before she comes back to practice law. So I think it has to look at what for the misconduct coupled with the standards is the appropriate sanction.
So just to restate, it sounds to me like you're saying that you believe our analytical process should be first considering the facts and the aggravators and mitigators, what is the appropriate sanction as a first step, and only secondly go to, is this a case amenable to a probation?
Yes, I believe so. I think we look at those standards and say, where does this case fall? And then based on the type of misconduct and the probation plan, is it then appropriate for probation?
So would you say that this is not an appropriate 3-year suspension and then probation in lieu of suspension?
My recommendation is 6 months because I think that's the appropriate length of suspension for the misconduct in this case. I do recognize why Mr. Ambrosio asks for a longer sentence or sanction. I know that he'll discuss that. But I believe this is a 6-month suspension and then the requirement of the reinstatement hearing. I believe I'm out of time. I'll just, if I may briefly just note, I believe that that's appropriate because of the misconduct in this case. We've got the dishonest conduct coupled with other misconduct. I didn't even get into that, but we've got competence, diligent, fee issues, safekeeping property issues, and dishonest conduct, both with candor towards the tribunal and to the clients causing actual injury. So I request a 6-month suspension.
Let me just follow up because I'm thinking historically here, because I understand that probably is that one consideration is that we just consider the length of suspension, what is appropriate under the facts. But there's also this other notion that I think that has kind of percolated through all these cases where we have a longer term of suspension, and that is kind of the kind of notion, let's hold that over the respondent's head. If there's something significant that happens in the probation, he or she is going to have a lengthy term of suspension. So you're kind of thinking that latter kind of idea is not appropriate?
In this case, and that's kind of hard because I don't think probation is appropriate in this case off the bat. I also don't think the probation plan complies with 227. So even, if we said a 3-year suspension, suspended for 90 days, and then with this probation plan, I don't think that's appropriate. But think that when we're looking at attorney discipline and we're asking this court to impose a sanction, it should be the sanction that we believe is appropriate for the discipline. Does that answer that question?
Yeah, 2 follow-up questions. Well, okay, I forgot what one of them was. Okay, you said it doesn't comply with 227, the probation plan. Can you just remind me?
So 227 requires that the probation plan be workable, substantial, detailed, and provide adequate safeguards to protect against the misconduct. And in my review of the probation plan, I think it's more overview. There are several conditions in it. It's several pages long, but if you really look at the kind of nuts and bolts of the conditions, I'll talk with my practice supervisor about calendaring practices. There's nothing in here to talk about fees, fee agreements, how she's going to properly keep like contemporaneous time records, any of that. There's nothing about taking on only areas of law in which she's competent. And then, of course, the bigger, concern that I think I really talked about at the hearing was the dishonesty and how do you supervise that and what verification is required in a probation plan. So in my view, the probation plan lacks really those adequate safeguards to protect her clients against and herself against future misconduct.
Okay.
What if we took into consideration the additional conditions the panel or the recommendations of the panel, added those on top of the probation plan? Does that change your view of it at all?
It does not, because we're still not that maybe helps with some of the concerns about the dishonest conduct. I still think that that's a difficult situation in any case, and this court pointed that out in Stockwell. But then we're still missing anything about fees. We're missing anything about competence, and those just aren't contained in there to be able to say these are the concrete, detailed things that the respondent is going to do to protect her clients from future misconduct.
I remembered my other thing. And in your recommendation to the hearing panel, you recommended the 6 months suspension and a reinstatement hearing. Is that still what you're?
Yes.
Okay.
And the purpose of that reinstatement hearing would be for her to be able to indicate what she has put in place. And again, I'll take this from the Kupka case where the court talked about ensuring a respondent has in place in their personal and professional life adequate safeguards to protect against future misconduct. And without seeing that in the probation plan, that's what the disciplinary administrator's office would want to see at that hearing. Thank you.
Thank you. Mr. Ambrosio?
John Ambrosio on behalf of the respondent, may it please the court, counsel. I wrote down this morning something that I thought of, and I'm glad I did after some of your questions. In one of your decisions, I think it was one of my cases, Janowski, you indicated your job as a court was to help salvage careers. Now that I believe it was in your decision. I've always thought that that was my job when I took on defending lawyers in these type of cases. Now, I will never get to my argument, which is why I love questions so much. What do we do to pay the money back? I've got money in my trust account, not all of it, but I'm willing to set up a plan which he pays back whatever amount of money you deem should go back to those people, the victims in this case. We're willing to do that. There is no vehicle at this time. This is off the record, and I apologize to my colleague about this, but I had my client talk to the probate judge. And the probate judge indicated if the court directs me to have a hearing, since this estate is closed, to determine what should be your fee, I will do that. So I hope your decision has in it, by the way, the judge, you need to reopen this case just to determine what her fees were. Now, let me tell you how these fees came about. I got involved in this case late, even before some of the investigation was completed. And the investigator indicated to my client when she was unrepresented, I can't decide how much you should have charged in that probate case. And I understand the probate judge sets those fees. That's part of what she did wrong here. So he had her put together a record after the fact as to how much time she has there. And yes, there are a lot of review. But if you look at my time sheets in the case that's going to be in February, you'll see review of certain transfers, review of this, review of that. That's not unusual. I understand why it's in there, and I understand it should say TC with X, Ray, upcoming hearing, TC with Jones. I understand that. It was not detailed. It was cobbled up after the fact. And that's a valid point, and that's why we need to have somebody determine what a fair fee is to salvage her career. And my colleague is right. I want longer probationary periods because I don't want conduct in this case and other cases to happen from my clients again and again and again. I like holding something over the head of,
You mean suspension period,
what did I say?
probation period.
Okay.
You mean,
Absolutely.
gonna ask
Justice
you-
Rosen, you're right. Even I occasionally misspeak.
you're an advocate for these.
Absolutely.
And so
And on that point, I totally understand from your perspective as an advocate. And I'm not going to ask you to set aside your advocate hat
Well, can't happen.
necessarily.
It won't happen.
But I will ask you to consider that this is a precedent setting and a precedent abiding court. And so I just want you to comment on the potential problem of that, where let's say we adopted your agreement, or we adopted your recommendation in this case. So it's a 3-year suspension. A few years down the road, the next case comes up, and remarkably, it is like on all four legs.
Okay.
It's almost identical. And we look in our precedent, and our precedent says this is a 3-year suspension. When maybe in reality, it's only a 6-month suspension. That's a problem, isn't it?
Not for me.
I understand, and that's why I asked you.
Not for me, it's not a problem.
Well, but this court is going to be rendering a judgment
I
on your
understand that.
recommendation, so persuade
Could be
me,
for a future
persuade
case.
me that it's not a problem.
It could be what Justice Stiegel is saying. It could be for one of your future clients. It could be major your problem.
It's conceivable, but in this case, I hear what you're saying.
Well, I
Absolutely.
want to give you an opportunity to persuade me why my concern is misplaced.
And I can't, in all honesty, I can't tell you that your concept is misplaced. I can't do that.
Well, even in this case, though, if she has a 3-year suspension that is stayed for a 3-year probationary period, and she violates terms of the probation, a week or 3 months after such an order is implemented, then she's suspended for 2 3/4 years.
The disciplinary administrator's office, if that occurs, is obligated to file a motion or an application, and we have a hearing in regard to that, is my understanding of the way it works.
And why would we reverse our decision then? I mean, we would of course consider whatever happened, but then we have on the books that, well, we thought a 3-year suspension was appropriate, so now you have to rebut that. Right?
I hadn't thought of this before today. I really don't have I'm being honest with you. I don't have a good answer. And I usually can be glib enough to give you an answer and everything, and I don't have an answer. It's not misplaced. I hear what you're saying. I do think there was probably a family disagreement here that I don't know that's going on. I hear what you're saying. I don't know. But let's look at this case and why I want in this case a 3-year suspension, because I want it held over her head. I don't want this conduct to continue, and we can't handle it with a shorter suspension. Frankly, I'm not sure I will ever file a motion for her to get off probation at the end of that 3 years. She may come to me and say, John, just don't file. And if I don't file a motion to end that suspension, it continues until she dies or until she stops practicing law.
Don't you get the same thing if you have a 6-month suspension that stayed for 3 years?
Okay. These are, and yeah, maybe a problem down the road, but I worry about these problems on this case, and what happens later, I decide how to handle it then. But I want you to just think about something else. She'll pay back whatever restitution you want. But I'm going to get to the important part of this case, other than this analysis of what you're supposed to do and what the discipline should be. My colleague asked for a 6-month suspension. which doesn't help at all in this case. It slaps her on the hand. We have a reinstatement hearing. The panel once again says she's reinstated with the probation plan. So she's been punished, but we don't address in any way what led us here. The conduct that was visited upon my client, and read the testimony, that led to PTSD, and led to anxiety, and led to depression. The sexual abuse that I won't mention because we're recording this was visited upon this woman by her father, her mother, her uncle, and his wife that went on for years. It's amazing that this woman went to college and got out, went to law school and got out, practiced law for all these years. We need to look at that in this case. I don't care what you do on these other issues. I want you to look at it.
Okay, so I understand that what happened was horrific.
Absolutely.
Right. I mean, there's no dispute about that. I mean, I don't even know the details, but horrific. But she went 37 years, I mean, with a blip in 1999. She went 37 years and she wasn't dishonest. She didn't engage in knowing misconduct. I mean, so I mean, it's,
We're seeing people come forward, Your Honor, now, 36 years after they were sexually abused, when it suddenly hits them. It certainly hits them like a sledgehammer. What was visited upon them? The I-2 movement.
okay, so that's a mitigating. What do you do though about the ABA standards, okay? Which is suspension is generally appropriate when a lawyer knew or should know that she's dealing improperly with client property and causes injury. Or that's 4.12, 4.42. Suspension is generally appropriate. You know, I mean, really what you're asking for is a suspension, but that it be stayed.
That's correct. And that's not addressed in those ABA standards, is it?
Well, why should it be stayed?
Because of the mitigating factors. That's why it should be stayed, because how this woman has worked her whole life. We're lucky she's alive. Every time I get a call from them, I'm hoping it's just to say, John, can I do such and such? It's not, I'm considering suicide again, or I'm considering running my car into a
Well,
bridge.
doesn't that exactly show why she should be suspended?
No, that shows why she
But
should be
please
given a
don't,
chance.
please don't talk to me like that.
Oh, I talk to everybody like this, and if I apologize, I was just, this is why I'm Italian and I'm loud. And
No,
when I disagree, I
that's not how
disagree.
you treat the court. This is completely inappropriate. I don't let my children talk to me that way, but I'm sitting up here in a robe and you're screaming at me. That is inappropriate.
If I was screaming at you, you would be right, Your Honor. I was loud. I was being an advocate. And if you took it the wrong way, most people would
I
apologize.
took it the wrong way.
Well, that's what, you obviously did take it the wrong way. But it's not about me, we're about her right now. My client would like to address the court. May she?
She may.
Susan.
I appreciate the chance to address the court today. I would first like to apologize to the Andrades and the Casanovas. They deserve better, and at the time I was not able to provide it. Events had overtaken me, and I was unable to do better and not able to see what I was doing. I fell far short of what they were entitled to expect, and I could not even see it. I'm grateful for this entire process. This complaint started in 2021. The behavior that was complained of was from 1919 through 2022. In going through this complaint process, working with my attorney, speaking with my psychologist, working with my practice supervisor, going to resiliency group through KLAP, working through getting the right medications in the right amounts for my depression and anxiety, keeping on a strong path, seeing my practice monitor. I have not been alone, and I'm grateful for that. This process has shown me not just where I went wrong, but where I am now going right and how to keep going right. Discipline means correction and teaching, And I have learned much about the practice of law and people's kindness through this. The generosity of our profession has been so warming for me. I love practicing law. Over my career, I have litigated insurance antitrust cases, Miller Act cases in federal court, fraud cases in commercial construction work, fraud in employment law, airplane repair and home building, construction disputes of government projects. There's nothing like wrestling a verdict from the facts and seeing some measure of fairness done for clients who put their trust in you. Nothing. I am most proud of working in family law. I've been a family law attorney almost exclusively for the last 15 years. I was counsel in a number of cases through the 2010s where this court's ruling in Frazier versus Goodshall was used to support and obtain rights for gay persons to parentage of their children. I've had great satisfaction in child in need of care cases protecting children from ill treatment, which is something that didn't happen for me. I've had the great privilege of shepherding families through divorces and made it my practice never to add anything to the process as a lawyer that would keep a family from being a family on the other side of the divorce process. To me, it's the most important area of law, domestic law, because it is where most people have their only exposure to the legal system, and it is critical to be fair, kind, and thorough. It is a privilege, and I have been grateful for the chance. I can't imagine what else I would have done with my life. I hope you've seen me today for who I am and not just what I've done, but what I can and hope to do. If you have any questions for me, I'd be happy to answer them.
You reserved 3 minutes.
Madam Chief Justice. Justice Standard and Justice Biles, I wanted to address the legal fees. And Justice Paul, you might also ask me about where the information was. I'm looking at Disciplinary Administrator Exhibit 11. It can be found at Bate Stamp 162 of Volume 3 of the record. And this is what I could picture in my mind. But the top of it says legal fees to Carolyn Sue Edwards, and this was created by the client. This is where I got my assumption that it was paid out of the estate. It shows the date that the check was paid, and then it says account Louis A. Andrade Estate -checking. That was where I got my assumption that that's where it was being paid out of, because we only had evidence on aggravating and mitigating at the hearing because of the stipulation. We never asked those specific questions of whether that's how they were, qualifying it for themselves or whether that's actually where that was coming from. But that's where I got my assumption on that
Thank you.
payment. I just wanted to briefly indicate that the purpose of lawyer discipline is to protect the public. It's not a slap on the wrist or something like that, a punishment to have a suspension. And that in this case, in light of not just the dishonest conduct, but that of course makes it difficult for supervision, but in light of the other misconduct, the 2 complaints, the actual injury to those clients coupled with the ABA standards, it is our office's position that a suspension is appropriate. And then in light of all the testimony and the mitigating information, coupled with the concerns that led to the misconduct, we're asking for that reinstatement hearing to ensure, and using her therapist to testify at the hearing that she needed consistent and proper support to help her. And his concern is that she would not easily then fall back into old patterns relating to the trauma of shutting down or simply appeasing situations that shouldn't be appeased, so that we would want to see that at a reinstatement hearing to ensure the protection of her clients and so that she could then return to the practice of law. Thank you.
The court will take this matter under advisement.